Welcome to our webinar. This is our Lunch and Learn session on the 9th of July, and we're focusing today on handling difficult performance reviews. I'm Liz Burley, Director of Burley Law Limited. I'm an employment law specialist with a few years under my belt. So we need to just move the slides on. Thank you. Before I get started, we're going to look at just an overview of what we're going to think about today. We have about 25 minutes to think about performance reviews, why they matter, what sort of best practice is expected of employers and is likely to get the best out of reviews, some challenging or tricky scenarios as we go, and what are the key legal risks and takeaways. I have to say, in my years as an employment lawyer, I think it's managing performance that has caused probably some of the biggest headaches for clients. And it's the least favourite thing that managers have to do. They don't look forward to it. They don't want to have difficult conversations. They're not prepared for difficult conversations, not necessarily trained to have them or experienced in having them, and they fear getting it wrong. So many of the settlement agreements that cross my desk, where I'm advising either employers or employees, tend to be in this scenario. Employer thinks there's a performance problem, underperformance is evident. There hasn't been a process, no reviews, no monitoring, no PIP process to date, and employer just wants to get rid of this problem as soon as possible. And in that scenario, they go to a settlement agreement. They offer some money to bring employment to a swift end. And in that scenario, it's then about money. What is this going to cost the employer to get rid of the problem? Given the risk that is probably there's going to be some legal risk there involved. So why do performance reviews matter? Well, in any business, performance and productivity and performance culture is important to business success. That's a given. And I'm not here today to lecture you on why your business needs good recruits and needs to keep the good ones, and why it needs to perhaps move on people who are not demonstrating good attitude, good aptitude, the right skills and the right performance in role. But the key to good performance, of course, starts at the beginning with your recruitment. Getting the right hires in place and identifying very quickly into the relationship if you've made a bad hire is probably more important than what I'm about to teach you about in terms of process of managing performance problems further down the line. A lot of employers don't make good use of probationary periods for this, and life is about to get a bit tougher in the next couple of years because day one unfair dismissal rights are going to come into effect. I think the latest news is that won't happen until at least autumn 2026. It might be 2027. But when that happens, it will be fundamentally important to start managing these issues from day one, because otherwise you're going to get unfair dismissal findings against you if you've got no process in place to address bad hires and bad performance. But for the time being, anyone under 2 years of employment does not have the right to bring an unfair dismissal claim, and that remains the case until the law changes. So performance matters because of all of the good stuff. Culturally, it's a key to business success and growth. But it also matters because it's an important legal safeguard. If you have people who've got unfair dismissal rights, you will be at risk of claims for unfair dismissal if you do not follow good, fair processes, and if you haven't got a good reason to dismiss safely for capability. But under 2 years, you have to also be aware of risks around what we call automatic unfair dismissal reasons. They're things like whistleblowing, exercising rights in relation to health and safety, exercising other statutory rights, and of course the risk of discrimination claims if people feel that they're being unfairly victimised or targeted as a result of a protected characteristic like race, religion, disability, age, etc. I've mentioned some of the common challenges that employers often skirt around. These managing performance, having discussions with staff about problem areas is an emotional thing, and delivering the message is often uncomfortable. Receiving whatever response comes back is often uncomfortable, and things can escalate emotionally very quickly. People aren't trained to handle receiving feedback and often aren't trained to give it as managers. There can be unclear expectations. So I talked about your recruitment process and induction when people are hired. The key to getting all of this right and getting the best out of it is to set those expectations from day one, from the get-go. So having a standard induction for all hires about what their role requires, what skills and aptitudes they're expected to demonstrate. Of course, you'll have gone through all of this in your recruitment exercise, but going through it when people are hired is also very important so that they understand once they're in role what is expected of them, what they're expected to do to show up every day and deliver in their role. And that's documented so that it's something that you can refer back to if and when things aren't going as well as expected. It also helps them to understand where they stand in relation to their role and then how they're going to develop going forward. And of course, having a framework, not a legal framework, but a performance framework that sets their expectations about how their performance will be monitored, when they can expect to have one-to-ones and receive feedback, and when those more formal performance reviews will take place, whether they're 6 months into employment or a year, or quarterly, whatever that is. And there is no set required process here. Every employer must do what is right for their business. Apart from the legal framework, nobody is going to tell you that you got the process wrong. It has to be reasonable and it has to be within your capabilities as a business. And policies and procedures that you have in place will be very important to determining what that process is. So if you've got something written down, be consistent in following it. The legal framework, as I alluded to earlier, is in the Employment Rights Act. That's the law on unfair dismissal. And just very quickly, that law says that to dismiss fairly, whether it's performance, misconduct, or any other reason, you have to have two elements in place and satisfy an employment tribunal of them. One is a genuine fair reason for dismissal, and capability is one of those fair reasons. But you have to demonstrate that it was the genuine reason, that you weren't using performance and capability as the reason when it was some other thing that you were unhappy about. And the second limb of that test is that you act reasonably in treating that reason as the fair reason for dismissal. That is about your process, your approach, your communications with your employee, your attempts to manage underperformance, your warnings. All of that will go into whether you've acted reasonably. So that's the law on unfair dismissal. The Equality Act is relevant to discrimination. So I said earlier, whether people have got less than 2 years or more than 2 years, attempts to manage people, if they're done in a way that unfairly treats people because of their protected characteristics, you maybe not being consistent in the way that you approach the underperformance, you're treating them in a different way to other cases, or in the way that you behave towards them through the process, that could all give rise to allegations of discrimination. So you have to have both of those sets of law in your mind when you're dealing with underperformance. And finally, the ACAS Code of Practice on Discipline and Grievance Procedures is relevant. It has legal status. It's not a piece of law, but it's a statutory code of practice that tribunals can take into account if they're faced with deciding about claims for unfair dismissal or discrimination. And what the Code of Practice does is it sets out minimum standards that are required of employers. So, for example, if you don't have an internal policy and procedure for managing underperformance, you would be expected to comply with the minimum standards, at least in the Code of Practice. And that's relevant to any disciplinary warnings that you issue and also to dismissal of employees. That Code of Practice will share a link to it at the end of the webinar. The importance of it is that it'll cost you more compensation if you don't follow those minimum standards, up to 25% on top of compensation that an employment tribunal awards in a case of unfair dismissal or discrimination. So let's move on to think about some best practice approaches. Now, a lot of what I'm going to say here is probably fairly common sense, but it all feeds into the reasonable approach that would be expected of you if a tribunal were to come and look at this in as a legal claim. So preparation. Preparation is really important before you go into any meeting about any subject with an employee, because what you're doing is you're preparing for success and also for worst case scenario. So when you prepare for an underperformance discussion, you are going to think about what the relevant standards are for the role, the expectations that have been communicated, what the gap is between those standards and what's being delivered. And you're going to have examples and evidence ready to give to the employee, as specific as possible. So whatever the problem is, whether it's late attendance, disengagement at work, comments, whether it's missed deadlines, the evidence needs to be ready to show them. That way, you're going to be able to have a productive conversation, and you'll be able to have them engage with what you're showing them. If you're talking generalities, the likelihood is you're not going to get very much engagement from them. They're going to want to know what the evidence is and what specifically you're talking about. So preparing in advance of the discussion is vitally important, and also reviewing your policies and procedures on capability, if you have them, is very important. If you don't, look at the ACAS Code of Practice. But we're assuming, of course, that we're at a fairly informal stage here. You're not going into a disciplinary hearing. You're having a discussion that's informal. It might be the start of a process that leads to a more formal disciplinary situation in the future. But you're aiming to have a discussion now that may pull things around. You're aiming to support the employee, to understand, to have a two-way conversation, not just to tell them that they're rubbish, and to hear their feedback on the problems that you present to them. So during the review, be specific, but be constructive also. Give them the good feedback as well as the not so good feedback. What are they demonstrating well in their role as well as not so well? Focus on the behaviour and the output, not their personality. Personal traits are likely to possibly be linked with protected characteristics, but also be badly received by the employee. So we're focusing on the objective stuff here, not the subjective stuff, if we can. And give the employee space to respond to what you're saying. As I say, it's very easy in these scenarios when you're nervous and the emotions are running high to just use this as an opportunity for an information dump without letting there be space for discussion and agreement on the way forward. What you're aiming for as a follow-up from this meeting is an agreed way forward. Now, I've called this a performance improvement plan. Many people know that language. It's the usual speak in corporate settings, but in a smaller business, you might call it something else, like a performance support plan. The language is neither here nor there. You call it what you want, but you're aiming to have something on paper that records the discussion, the areas that are of concern, the agreed outputs from the meeting, support that's offered for improvement, a timescale over which improvement is expected, and some goals, some specific, measurable, achievable, realistic, and time-bound goals that are clear to the employee that you can monitor. So all of that is your best practice process for kicking off a possible performance management process further down the line. But here you're focusing on trying to resolve the problems rather than ending up in a disciplinary warning or a dismissal situation. Now, tricky scenarios that often crop up, and these are really common, particularly now, I think, when people are not used to being managed in the workplace. We've got very flexible and fluid ways of working. A lot of people are working remotely. They're not in the workplace physically as much as they used to be. So when they're met with meetings to talk about performance issues, attitude issues, whatever it is, they go straight to, I'm being bullied and I'm being harassed. Now, this is very common and it makes life extremely difficult for managing the process going forward. If you're faced with a grievance, it's not something that you can afford to ignore, because the ACAS Code of Procedure Code of Practice says that grievances must be investigated. However, my advice is usually that these are done as swiftly as possible. And if the line manager, if the grievance is against the line manager who is managing performance, but the performance review process is paused while the grievance is investigated. But aside from really, difficult behaviour, like maybe the way that the employee has been spoken to about their performance, specific comments that have been made, targeting that's gone on before the performance review discussion, history of some kind of harassment that's gone before. Aside from all of that, if this is just reasonable management of performance, then a grievance based on bullying harassment is not likely to get off the ground. Another tricky scenario, which again is very common, is that as soon as a performance review takes place that raises some difficult issues that need to be managed, the employee goes off sick. And this will particularly happen if there's a company sick pay policy that is more generous than statutory terms. So if an employee is on statutory sick pay only, they're unlikely to want to stay off sick. The statutory rate at the moment, I think, is about 118 quid a week. That is not going to be sustainable for any person who needs to pay bills. So I think the likelihood of that happening in an SSP environment is very limited. But if there is a more generous company sick pay scheme, 50% of pay, 4 weeks of pay, whatever it is, they're likely to stay off for the length of time that they can, and if they're signed off by the GP, of course. The go-to reason is likely to be mental health, stress at work. But the stress of work, of course, is the cause of it is the performance review that they're undergoing, and it's not going to be resolved until they engage with that process. As an employer, there's very little that you can do to go behind a GP's fit note. However, you can get occupational health involved and ask them to advise on the employee's fitness to attend meetings, whether that's remotely, online, or in person. It's very difficult for you to manage performance without meeting the employee and move the process forward and make decisions in their absence. So engagement with the employee is vital. And that might need to be wait until they've come back from sick leave. The key legal risk areas in performance management are discrimination, as I've said. Avoiding bias, open bias and assumptions, and being consistent is very key to being able to defend any allegations of discrimination and harassment. Harassment, of course, can take many forms. It's a legal claim, which is a little bit distinct from other discrimination claims. And harassment can include verbal comments. It can include non-verbal comments. It can include a course of behaviour. Somebody's being given difficult work to do consistently and being set up to fail. That can amount to harassment. So a very wide kind of claim that could be levelled against an employer if there's any sense that there's a campaign by a line manager to manage somebody out. Capability versus conduct is something to get clear on from the beginning. If you are concerned about somebody's output, their behaviour, then you need to get clear in your mind as to whether this is a capability issue or a conduct issue. Why? Because those are two potentially fair reasons for dismissal under the Employment Rights Act. But the way that you manage conduct would be different or shall I say misconduct would be different to the way you manage capability. So typically in a capability scenario, it's somebody who wants to do the job, appears to want to do the job, but can't do it. They're just not up to it. They're not demonstrating the behaviours. They're not demonstrating the aptitude. They might need a little bit of support to get them there, or at least get the opportunity to improve. And if they can't get there in the time expected with the right support, then this looks like warnings, first warning, final written warning, and then dismissal for capability. In misconduct cases, you're likely to be looking at somebody who won't perform. They're failing to follow the rules. They're openly insubordinate. They're missing deadlines and they've got no reasonable excuse. They're coming in late. They're telling you that they're not available when they should be for working if they're working remotely. All those kind of things are likely to be more about conduct than capability. And in that case, you would use your disciplinary procedure from the get-go. If somebody is demonstrating misconduct, failing to follow company rules, you'd issue disciplinary warnings from the start. You'd not use any kind of informal procedure to get there. If it's very serious misconduct, then you may be able to dismiss for gross misconduct without following any warning procedure fairly. A word on disabilities. So if you have an employee who has notified you of a disability, and we'll just come on to what that might mean in a moment, then there'll be a legal duty on the employer to consider and make reasonable adjustments. And those adjustments might be adjustments to their duties. It might be adjustments to their arrangements for work, hours of work, place of work. It might be additional support that they need, sort of hardware, software. It might be adjustments to a process of performance management. So the concept of reasonable adjustments only kicks in if you know or notice that your employee might be disabled. What do we mean by disability? Well, under the Equality Act, a disability is defined as a condition that's lasted or likely to last 12 months or more that has substantial impact on day-to-day activities. If somebody goes off with stress and mental ill health, anxiety, depression, that kind of thing, you might be on notice of a disability, but only, I would suggest, if your employee has a history. So getting to the bottom of whether this is a one-off or and it's just in response to a stressful work situation, or whether there's a genuine diagnosed condition is important, if you're going to go to occupational health to ask for an opinion there. I've covered unfair dismissal. You must show the fair reason and the process is fair. And documentation, I can't say enough about. If you end up in the worst case scenario of issuing warnings and then dismissal at the end of a process, then your employee is likely to challenge that if they've got over 2 years service in a case of unfair dismissal. And the usual rule of thumb in employment tribunal cases is that documentation wins cases and witnesses lose cases. In other words, if you have documentation, a well-documented process, you're clear from the very start about what's happened when, and you'll be able to point to documents that demonstrate that your witnesses will have to do very little heavy lifting for you in the employment tribunal hearing. If you don't have that documentation in place, it'll be all down to witnesses to win your case for you. And of course, witnesses can be unreliable. Their memories can be unreliable. They can say things in the witness box that you don't want them to say. So documentation, records of meeting, letters, evidence of support, responses, how you've handled the process in a documented fashion is going to be your best way forward if you're going to defend a claim. I should say, if you're dealing with somebody very early into their employment, unless you're aware of a protected characteristic that might be relevant to the performance problem, then I think a very shortened process is perfectly legitimate. There's no legal requirement on you to do anything other than bring employment to a swift close and issue notice that they're entitled to. There's no legal requirement on you to carry out an elongated process. So I would say the earlier on in employment that you are, the quicker this can be done. Your key takeaways then on this subject are support, if it's a capability issue that's genuine, structured process, and be aware of your legal risks at all times. Those that recipe should mean that you're setting up for success. And what that looks like in non-legal speak is, a fair and supported process to improve performance and protect your organisation. Useful resources that we have on the slide for you include the ACAS Code of Practice. Very useful to have that somewhere that you can reach out and look at it. If you're going to go into a process like this, there is ACAS guidance on discipline and grievances at work. That's also, those two things are on their website, and you can search them easily if you go to the website. Our YouTube channel at Burley Law has some valuable resources like previous Lunch and Learn webinars on key employment law topics, as well as interesting podcasts on healthy workplaces, various health-related topics and the workplace. And after this session, we will send you a free performance review checklist. So it'll remind you of some of the things I've talked about today. And it'll give you some ideas for open questions to ask in those review meetings to get the best out of your discussion. And that's the end of my my slot, so to speak. I'm going to invite any questions, but before we get to that, remind you that our next webinar, our Lunch and Learn, is on the 21st of August, and it's going to be all about harassment in the workplace and how to deal with any complaints or reports of harassment so that you protect your business effectively. And one last word on our HR starter bundles. These are bundles of documents that will protect you. They have key policies and contract templates, as well as other key documents for HR compliance. We have a bundle that's aimed at startup businesses, that's a starter bundle, and a bundle that's aimed at scale-up businesses for growing workforce. If you're interested and would like to know more about those, please contact us.